Hello everyone and welcome to Field Fisher's webinar series. My name is Hazel Grant and I'm the head of our privacy practice based out of our London office. Thank you so much for bearing with us. We started a little late today, but it's not our common practice. We do start on time normally. Today's topic is Brexit. We do have a webinar later on today, which will be on the topic of ad tech. I hope you might join us for that as well. However, before we get on to the thorny topic of Brexit, I have a few words about us and also a few housekeeping points which I'd like to raise. For those of you who don't already know us, Field Fisher is an international law firm with offices across Europe, in Silicon Valley and China, and our privacy team works across all of those offices. We are a collaborative team providing strategic and actionable privacy solutions. I know you're going to hear about that later on today. Turning to housekeeping, please do ask us questions as we go along, and we will try to take them when we can at convenient points in the webinar. If not, we'll respond to you after the webinar. Later on today, or probably tomorrow maybe, we will send you a link to the recording and a copy of the slides, so please don't feel that you have to scribble everything down or tap away on your PC to do that. A couple of other points, please do follow our blog and keep an eye out for further webinars beyond the one this afternoon. So now I'm going to turn to the topic of this webinar and our expert speakers. I shall ask Phil and Eleanor to introduce themselves and get right down to the topic. So Phil, can I hand over to you, please?
Absolutely. Good morning, everyone, and thank you very much for dialing into our webinar today. The good news is we're much better at the law than we are at webinar technology, so hopefully this should make for an entertaining session. My name is Phil Lee. I'm a partner in the London privacy team here at Field Fisher, and for a number of years I also ran our Silicon Valley office that Hazel mentioned earlier. Now, the topic of today's session is Brexit, a conscious uncoupling for data exports. And really what we want to do in this session is talk to you a bit about how we have gotten to where we are at this kind of stage of Brexit right now, what it means for the future of data exports, both from Europe into the UK and from the UK back into Europe and elsewhere around the world, and also to talk through some of the other sort of operational aspects of Brexit that you may not have already considered, always recognizing, of course, that there is an awful lot still up in the air. Now, Brexit is a hugely complicated issue, and in many ways, trying to grapple with it can sometimes seem as complicated as dealing with sort of nuclear physics or brain surgery. But we're very fortunate today to have on our call my colleague Eleanor Dews, who I will allow to introduce herself in just a second. But Eleanor is a real expert in this area. She's going to talk to you about sort of the overview of Brexit and what it means for the future of data flows. And then in the second half of the presentation, I will talk to you about some of the other operational impacts of Brexit. So with that, Eleanor, I'm going to hand over to you and let you take it from here.
Thank you very much, Phil, and good morning, everybody. So just to explain a little bit about my background, before I joined Field Fisher, I was actually a lawyer in the Department for Exiting the EU. So I have first-hand experience of grappling with all of this, and I really hope to demystify it a little bit for you and make it understandable. And prior to that, I actually negotiated the GDPR on behalf of the UK. And as I always say when I say that, I didn't draft the whole thing and it's not all my fault. So just to get that in early. Anyway, so, well, let's move on then to the topic at hand, a conscious uncoupling for data exports. And of course, you'll all realise that that is a reference to Chris Martin and Gwyneth Paltrow. And I suppose the question at the moment is it all going to be this divorce, as it were, between the UK and the EU, as wonderfully functional and good-humoured perhaps as Gwyneth Paltrow and Chris Martin? I'm not so sure it will be, but anyway, let's work through some of the issues here. Right. So as Phil said, in terms of the structure of the session, I'm going to deal with a broad overview and data exports, and then Phil will be looking at other operational impacts. So what am I going to try and achieve here in this particular segment? As Phil was saying, this really is complicated stuff, but I want to get you into the position where you would be able to explain to somebody in your company what the overview is of the next few months in terms of Brexit developments, what the milestones will be, and secondly, the 4 main steps that you may need to take to prepare for the end of this year. So that is the intention in relation to this segment. And how is it going to be structured? Well, I'll give you an overview of where we are now, where I think we're heading, what this means for data protection compliance, and what you need to do in terms of practical steps in order to be ready. So I've got here a rather beautiful monument with 3 pillars, because I think it's quite helpful to think about where we are now and our UK relationship with the EU in terms of 3 phases, as it were. So firstly, the phase when the UK was an EU member state. Secondly, the phase that we're in now, the transition period, as it's called. And thirdly, what will happen post-transition period, so at the end, potentially, of this year. So where are we now? Well, as I'm sure you all know, the UK left the EU on the 31st of January. So the UK is no longer an EU member state. And as I mentioned just now, currently we're in the transition period. And that is a period whereby the EU acquis, as they call it in Brussels, the EU treaties and all the secondary legislation under those treaties still applies to the UK in the same way as it did before. So in many ways, there's no real difference in our relationship with the EU now compared to when we were a member state, apart from in relation to one really important point. The UK is not represented in any of the EU institutions at the moment. That's the main exception. So when the EU meets to decide things, it meets without the UK present. In terms of the GDPR, that means that it still applies to the UK in the way that it always did before, subject, of course, to that exception. So the Information Commissioner isn't automatically allowed to come to the meetings of the EDPB, although there are exceptions which could allow for that, and we'll talk about that in a little while. So things really are currently as they always were in many, many respects. And from an operational perspective, there's no real difference in terms of the way that data protection law and standards apply in the UK as compared with in other EU member states. Now, what happens at the end of the year? And I've put 31st of December 2020 question mark, because there are some signs that because of the current crisis that we are all experiencing with COVID-19, that the timetable may shift back. Although I noticed yesterday in Boris Johnson's press conference, somebody asked him, does this mean that Brexit's going to be postponed? And he didn't really want to get drawn on that. He said, oh no, Brexit's already done. But I think realistically, I think there is a strong possibility that things will have to be pushed back. And it hasn't come out very much, but I did see in the Telegraph a couple of days ago that the talks which were meant to happen between the UK and the EU this week did not go ahead. Anyway, so we'll see. But at the moment, what we are expecting, and it's even set out in UK law, is that there won't be any extension to the transition period, and we will leave on the 31st of December of this year. And a lot of people have said that could be another cliff edge moment. So there were lots of mentions of cliff edges in terms of a no deal Brexit, but this could be similar, because if the talks don't go well, then there is a possibility of the UK simply falling out, as it were, of all the treaties that I've talked about on the 31st of December 2020. So that is, I think, a possibility that we need to bear in mind. So what preparations are currently being made for the end of the transition period? Well, if you look at the statements coming out from the UK and the EU and the negotiating mandates which set out how the negotiations are going to proceed, it's very clear that in terms of what the UK wants, it is an EU adequacy decision, and that's very, very clear. The EU, of course, is also preparing for that, and those talks, although having probably stalled, I think, this week, the intention is for those to continue, and for that adequacy decision to come in by the end of the year. So that's why I've got the stamp quality controlled approved. The EU will be looking at our regime and considering whether it's adequate. And because it's essentially the EU's regime, because as I'll be talking about later, we're turning the EU regime into a UK version of that same regime, one would have thought that wouldn't be such a difficult thing to achieve, that our regime would be deemed to be adequate. But there are some potential stumbling blocks I'm going to talk about. So anyway, so that's the first bit of the preparation, EU adequacy for the UK. And secondly, the UK is also developing its own international transfers regime at the same time, which is supposed to be coming in at the end of this year. So that's also something to be aware of. So I mentioned that there might be some slight difficulties with the EU adequacy decision. There have been quite a lot of articles about all of this. The potential and stumbling blocks are three, essentially. The first is the time frame. It's extremely ambitious to have the adequacy decision in place and in force by the end of this year. And no country has ever managed to get an adequacy decision so quickly. So the time frame is a potential stumbling block. Secondly, I've mentioned the Investigatory Powers Act. When an EU member state signs up, as it were, to become that, to have that status, there are certain areas which it doesn't sign up to the EU for, if I can put it that way. And one area is national security. That remains something that isn't part of the treaties and isn't part of the way that the EU cooperates. That's an area where member states can still have their own legislation and the EU isn't allowed to look at it. This is a matter that's between member states and not through the EU treaties. Now, when the EU is assessing a third country for adequacy, it actually has to look at that country's national security legislation. So where the UK was an EU member state, our national security legislation and the Investigatory Powers Act is the most important piece of legislation in this space. That was outside the scope of what the EU could consider, but now they have to consider it in terms of adequacy. And there are some commentators who say they're going to look at our national security legislation and say, we don't like it. It's quite interesting to look at some of the documents coming out of the governments at the moment. Last week, there was quite a detailed suite of documents about adequacy negotiation. And there was quite a long document about this particular issue, our national security legislation, and very prominent, which is something I've seen a lot of UK representatives mention over the last few months, was the fact that the UN Special Rapporteur in this area has said that our national security legislation is something like exemplary. So the UK is really holding on to that and saying, look, we've got really good national security legislation with lots of checks and balances. So we'll see about that. But anyway, the Investigatory Powers Act is something that people think possibly the EU might ask for changes to, or say this bit doesn't work, you need to rethink this. So that's a potential stumbling block. And thirdly, further divergence. It was quite remarkable at the beginning of the year. There was a very short written ministerial statement from Boris Johnson saying we want to diverge in lots of areas. The words he used was to have our independent policies in these areas, and data protection was mentioned there. And everyone thought, oh my goodness, are we going to have a completely new regime here? I don't think that's the case. And if you look at all the documents that are coming out at the moment, that really isn't the plan at all. I think what that meant was we are going to choose, if we do stay aligned with EU standards, to do that as a sovereign country, not that we were going to suddenly change our standards and move in another direction. But anyway, I put that as a question mark because that's something that people have worried about. I think probably that isn't such a stumbling block, actually. And what about the UK's own international transfers regime that I mentioned? What's that going to look like? Because that, as the UK has said in all of these documents setting out its position, is something we're going to be developing over the next few months. We have absolutely no idea what that's going to look like at all. But from sort of soundings coming out of Whitehall, if I can put it that way, it seems as if the sense is that anything that's light touch and not too difficult to comply with and flexible whilst having high standards is what the government is looking to achieve. So I think we can expect to see something which is aimed at trying to make the burden of international transfers less onerous, but at the same time protecting the data that's coming out of the UK. So it'll be interesting to see what that looks like. And the UK has specifically said that they're going to have a sort of adequacy regime themselves and going to be assessing the EU in relation to that adequacy regime. So that looks interesting as well. And of course, adequacy is the least burdensome way of flowing data, as it were, out of your jurisdiction to a third country. So we'll see what happens with that. So in a little bit more detail now, what does the end of the transition period look like in terms of the law that will apply to the UK in terms of data protection? And we'll have the so-called UK GDPR, and that's set out in the legislation. I'm just going to, at the end, mention the relevant legislation here, but the legislation that paves the way for Brexit says that we're going to have a UK GDPR, which essentially just means that we're saving the GDPR, turning it into UK law and making a few amendments, like where the GDPR mentions the member states, will change that reference so that it works with the UK as being a separate country, as it were, no longer an EU member state. And where you mentioned the European Data Protection Board, for example, those sort of references will go because we won't have those sort of mechanisms anymore for working in the same way with the EU as we did as an EU member state. Now, the UK GDPR will be interpreted in a special way too, because the idea, certainly under Theresa May's government, was that we had to have the EU law that we saved, that we turned into UK law, with the same interpretation, that it meant the same thing, and that meant preserving the Court of Justice, the European Court of Justice's case law. So all the case law that we're familiar with in looking at the GDPR and the European Data Protection Regime would be saved, and that gives some continuity because people can be confident about what a court would say the UK version of the GDPR would mean. Now, interestingly, under Boris Johnson, the Brexit legislation has put that position in doubt because there's now some possibility for a minister to prescribe a test to the courts where any court could depart from the case law of the Court of Justice from day one when we leave. So I've put question mark past case law of the CJU, the Court of Justice of the European Union, because it may be that very quickly the UK starts to diverge on the meaning of the law that we've saved. So you could get quite a lot of challenges potentially in relation to the UK GDPR with individuals and companies saying actually it means this and bringing a case about it in the UK courts. And the UK courts, of course, will be interpreting what is a UK regime, and they won't be bound by any other court, including the Court of Justice, in relation to how they decide that. So that could be a big change quite quickly in terms of the data protection legislation that we've saved. So question mark, will the past case law of the Court of Justice still be relevant? And also there'll be, of course, new UK case law to interpret that UK regime. If there's no adequacy decision, then something quite complex is going to be happening. And I just want to take you through that briefly because it's important to know about. So we'll have the UK GDPR, as I just explained. But the withdrawal agreement, if there is no adequacy decision, deals with that situation in a particular way. And it's Article 71(1) of the withdrawal agreement that's relevant here. And I'll just take you through what it means. So it sets out that if you have data that's come from outside the UK and you're processing it in the UK, either during EU membership or during the transition period, or if you're processing it under the withdrawal agreement, but I think most of you won't be, because that's going to be things like the Home Office processing data of EU citizens, for example. But basically, if you're processing data that came from essentially from the EU during EU membership or during the transition period, you have to process that data in the following way: in accordance with the GDPR as frozen at the end of the transition period, so currently we think 31st of December 2020, and you have to interpret it in accordance with the past case law of the Court of Justice and new case law of the Court of Justice. So that is a marked difference from how you treat the UK GDPR data, as it were, data that hasn't come from outside the UK. So that's an area there where we are having some quite significant conscious uncoupling, if I can put it that way. So I've illustrated this with sort of a stream, different flows, because potentially now we've got 3 different regimes at the end of the transition period. We've got the UK GDPR, as I explained. We've got the frozen GDPR, which is catered for under the withdrawal agreement, which kicks in if we don't have an adequacy decision. And potentially lots of you will still be subject to the EU GDPR because of your EU establishments or because of the extraterritorial provisions in the GDPR. So 3 potential sources of data protection law. So what should you be doing this year with this really complex situation potentially coming to fruition at the end of the year? Well, keep an eye on what's going on. That's the most important thing to do in order to be prepared. So keep an eye on the adequacy negotiations, because if they're going well, you don't need to worry about the frozen GDPR and Article 71(1) of the withdrawal agreement. So that's important. Keep abreast of what's happening there. What sort of messaging is coming out? Does it seem like, although we had a really ambitious time frame, it's actually going to be okay? Secondly, keep an eye out for any extension of the transition period. Now, I think, as I said, although the government isn't wanting to say that the transition period is going to be extended, I think there is a high likelihood that it might actually. So keep an eye out for that, because there may be a bit more time actually to make any changes you need than what it appears to be the case at the moment. And thirdly, have a look at announcements about the UK international transfers mechanisms. I expect that there will be some leeway that you wouldn't have to put those in place straight away at the end of the year. The government, I think, wouldn't want to make such a sort of quick change in the law. So I expect that you'll have time to ease yourself into those, as it were. But it's worth looking at them, because if they really are quite labour saving and quite helpful, you might decide that you want to put those in place sooner rather than later. So now the 4 steps that I mentioned at the start. There are 4 different work streams, as it were, that you need to be thinking about. Firstly, if there isn't an adequacy decision, you need to see, have you got data that came from the EU during our membership of the EU or the transition period? Because if there's no adequacy decision, then you need to implement what's required under Article 71(1). So it's the frozen GDPR that applies, and the Court of Justice's case law, both the past and the future case law, applies to that set of data, as it were. Secondly, you need to look at what the UK GDPR framework is saying, and as I say, it's going to be more or less the same as the the text, as it were, of the GDPR, because that's what we're saving. We're saving the text of the GDPR and turning it into the UK GDPR. But there's a real question mark about ministers bringing forward this new test where courts can depart from day one, really, from the Court of Justice's past case law. And that means that the meaning of the UK GDPR might change quite quickly. And of course, there'll be new UK case law in any event, even if ministers decide not to make that dramatic shift in relation to the case law. So you need to keep an eye, basically, on divergence, the UK GDPR diverging in terms of its meaning from the EU version. And thirdly, a lot of you will still be caught by the EU GDPR, either because of establishments in the EU or because of the extraterritorial scope of the GDPR. So you also need to keep on top of that regime. What new cases are coming out, and they will be binding, of course, on entities that are caught by the EU GDPR. And of course, there's the past case law of the Court of Justice to take into account as well. And fourthly, be prepared to put in place mechanisms for transferring data from the EU to the UK, and that will mostly be standard contractual clauses if there's no adequacy decision. But also have a look at the UK international transfers regime. Are there any mechanisms that need to be put in place there for transferring data from the UK to the EU or to third countries? And you may have decided that standard contractual clauses are the best way to do that to begin with, and that's fine. As I say, I don't think there's going to be a cliff edge. I think there will be time to put in place these new mechanisms. But if you're starting that process afresh and there is time, it might be that the UK transfer mechanism is preferable. So that'll be a decision for you to make, but have a look at the messaging that's coming out of the UK government in relation to its UK international transfers mechanisms. So I hope now that I have given you an overview of what might happen in 2020, or perhaps a slightly more a longer time frame for this, but the main Brexit developments, so the adequacy negotiations and the UK international transfers mechanisms, those are the really key things to be looking at. And the 4 steps that you might take. So I hope those are clear. As we said earlier, the slides will be being sent out to you. So I hope that those will be useful. I've also added a quick bibliography here. The key legislation is, of course, the withdrawal agreement itself. That's the international treaty, as it were, which paves the way for the UK's exit from the EU, and also the transition period which we're in now. So that's what's in force at the moment. And of course that brings in, as I said earlier, all of the EU treaties and the GDPR. They still apply to the UK during this transition period. But also this is where you'll find this Article 71(1). So that's anticipating, as I said, what happens at the end of the transition period. So that's all to be found in the withdrawal agreement. Then there's the European Union Withdrawal Act 2018. That was essentially, to begin with, a no-deal piece of legislation, and that's what saves the GDPR and turns it into the UK GDPR. That's been amended somewhat by the next piece of legislation, the European Union Withdrawal Agreement Act 2020. And the main changes there really are that it allows for the transition period, and this is where we have the domestic legislation which says we're not going to be extending the transition period. Of course, that could be changed. But a number of things to be aware of there in that legislation. And also the statutory instrument which makes the changes to the GDPR. I've set out the name there. It's rather the EU exit regulation. It's a bit of a mouthful to say, but that's something also to be aware of and to have a look at. What changes have been made to the GDPR when it becomes the UK GDPR? Well, that's where all of those are found. So I hope that's helpful. It is a complex jigsaw puzzle, really, to get your head around. Very happy, of course, to assist with clarifying any of this and assisting with what steps you can take to prepare for the end of the transition period. So that brings me to the end of this, and now I'm going to hand over to Phil to look at the other operational impacts of the Brexit saga.
That's great. Thank you very much, Eleanor. Good. Well, thank you for that comprehensive overview, Eleanor. As I think anybody listening to that will have appreciated, this is a very, very complicated area. To a degree, we are still crystal ball gazing a little bit because everything is still very uncertain, and much hinges on what happens over the course of the coming year in terms of where we get to with the trade negotiations, what happens in terms of whether the UK is granted adequacy, and the path that the UK decides to carve for itself in terms of its own domestic UK data protection legislation. But the second half of this presentation, Eleanor's really dealt with the difficult part, which is how a data flow is going to be managed. But the second part of this presentation is, what are the other things that you need to think about? What are the consequences of the separation of the UK from the EU, and the fact that the GDPR, the EU GDPR, will no longer be applying in the UK. So in the next half of this presentation, what I want to do is take you through sort of three key areas. First off, what will happen once the EU GDPR no longer applies in the UK? In other words, what we're thinking about there is, what does it mean for UK businesses who are no longer able to take the benefit of this harmonized regime that used to apply throughout all of the EU, including the UK, to enable the free flow of data between these member states and to create a harmonized set of rules. The next part is going to be looking at what is the impact of having new separate UK domestic data protection legislation, this UK GDPR that Eleanor talked about. What are the consequences of that, and where are we going to see perhaps duplication with the EU GDPR, and what does that mean for businesses? And then finally, what are the other impacts? What are the things we need to be thinking about? And in particular, we will be looking there at some of the contractual impacts of Brexit. So if we can just move on to the next slide. I think, Eleanor, you may still have control at the moment. Yes. There you go. Thank you. So the first thing to understand, kind of really to reiterate what Eleanor was saying previously, when we are looking at the laws that businesses are going to have to comply with going forward, we are thinking about two separate regimes. We are thinking about the EU GDPR, and we are thinking about the UK GDPR. Oh, no, I think control has been passed over to me. Just two seconds. Let me bring this up. Excuse me a second. Eleanor, if you're able to take back control of the slides again at the moment, it's not going to let me do that here.
Right, okay. Okay, I've got control.
Thank you. Just go back one slide. I'll carry on talking in the meantime. There we go. So we need to bear in mind that we are going to have two separate regimes, the EU GDPR and the UK GDPR. And they are separate pieces of legislation, and that's a really important thing to get your head around, because one of the things that I've heard said many times from clients is that it's not going to be a big deal. The GDPR is still going to apply in the UK, and that is true. But essentially, the way that it is working is not that we are having the existing European Union GDPR just apply in the UK. As Eleanor explained earlier, what we are doing is saving the EU GDPR into the UK domestic legislation. And Eleanor doesn't like me saying this, but I'm going to say it anyway. The way I think about it, it is like copying and pasting the EU GDPR as it stands today into UK law. And effectively, that's what the EU Withdrawal Act does. It copies that EU GDPR into UK domestic law, and then the EU exit regulations that Eleanor was talking about earlier, what they essentially do It's a bit like when you're in Microsoft Word and you're editing a document and you do a global find and replace. The EU exit regulations are kind of the equivalent to that. They scan through the GDPR as it's copied into UK law, and they replace all those EU elements with corresponding UK equivalents. So as Eleanor said, references to the European Data Protection Board might be replaced with references to the UK ICO and so on. But they are two separate pieces of law. And what that means is that if you are an organisation that operates across both the EU and the UK, you are going to be subject to both pieces of legislation. The only time where you would be subject to only one would be if you were a wholly domestic UK business established in the UK and only doing business in the UK, then you'd only be subject to the UK GDPR. Similarly, if you're a wholly domestic EU business established in the EU and only doing business in the EU, you would only be subject to the EU GDPR. But if you were established in either territory and providing goods and services to or monitoring the behaviour of individuals in the other territory, you are going to be subject to both regimes. And what that, of course, means is that given the similarity of both laws, there's going to be a lot of overlap, and increasingly over time, there is going to be divergence between those two regimes. Can you advance the slide, please, Eleanor?
Yes.
So let's look first of all, what does it mean if you're a UK organisation that is providing your goods and services or monitoring the behaviour of individuals in the EU, but the EU GDPR doesn't apply in the UK anymore? Well, as we've mentioned, if you're established in the UK, you are going to be subject to the UK GDPR, and equally, because you are providing your goods and services into the EU or you're monitoring the behaviour of individuals in the EU, you're separately going to be subject to the EU GDPR. Now, again, they are separate regimes. They're regulated by separate data protection authorities, the UK ICO for the UK and the EU authorities for the EU GDPR. But what happens then if you have a data breach? Well, the simple reality is going to be if you have a data breach that affects all your data, the likelihood is that you are going to have to report that data breach both to the UK ICO and separately to the relevant EU authorities. So in effect, you get one breach resulting in two sets of breach reporting obligations, each under the different regimes. Now, in turn, what that then leads to is the possibility that you may be investigated by the regulator for each law. So again, the ICO in the UK and the relevant EU authority or authorities over in the EU. So you could then be subject to multiple investigations, and quite potentially, you run the risk of being fined twice. And keeping in mind that the UK GDPR is going to maintain the same level of fine as the EU GDPR, that means you could be in line for some very big penalties under both sets of law. Now, there is the obvious question, which is that, but would authorities really do that in practice? If the UK knows that the EU is already investigating the breach and vice versa, are they really going to be, are they really going to feel the need to kind of investigate it as well? And I think the thing to keep in mind there is to, again, going back to my point, to remember that they are separate legislative regimes regulated by separate authorities that have their own statutory responsibilities to investigate breaches of their law. So in principle, yes, there would be those separate investigations and it could result in some fines, although again, duplication of fines, but again, how that works in practice, I think remains to be seen what the cooperation between the authorities might be as a result of the trade negotiations that are still ongoing. But we need to wait and see a little bit there. We can move on to the next slide. Now, the next important point, of course, is this issue of the one-stop shop. Now, a lot was made when the GDPR came into force about the benefit of this one-stop shop, this idea that if you were an authority that engaged in, if you were a business that engaged in cross-border processing, that's processing data across lots of different territories, you could effectively fall mainly under the jurisdiction of one regulator, where you have your main establishment. And the idea there was to kind of save you being subject to investigations from lots of different EU authorities. You could just kind of fall under the competence of one main authority. But that rule only applies if you have your main establishment in the EU. Now, once the UK is no longer treated like an EU member state, once we are wholly outside of it at the end of the transition period, UK established or entities will not benefit from the one-stop shop under the GDPR. And as a consequence, that means that any UK business that is, again, providing goods and services into the EU or monitoring the behaviour of individuals in the EU is potentially exposed to the oversight and jurisdiction of every EU authority under the GDPR, unless, of course, they can show that they have a separate central administration main establishment in the EU. But if that's not the case, then they risk exposure to all of the EU data protection authorities. So we lose the benefit of the one-stop shop. We can move on to the next slide. And there is also this requirement that exists under the GDPR that if you are a non-EU business, you have to appoint an EU representative. And the purpose of the EU representative is essentially to be a person, a legal or a natural person that represents the non-EU entity in the EU, and so can act as a point of contact for data protection authorities in the event that they want to kind of raise some issues with the non-EU entity. They have a local point of contact in the EU that they can engage with. Now, again, once the UK is treated as being like an EU member state after the end of the transition period, the UK will be like any other non-EU country, and that means if you are a UK business that doesn't have offices in the EU, you will need to appoint an EU representative to represent you in the EU under the GDPR, just like any other non-EU business. So again, another practical effect you will need to think through. Next slide, please. So those are the consequences of being a UK business that no longer benefits from the GDPR applying in the UK. But what are the consequences as well of us now having this separate piece of domestic UK data protection legislation, the UK GDPR? Well, the UK GDPR is going to look very similar to the EU GDPR, but it is just, of course, going to be the UK equivalent of it. And one of the things that was, very widely reported when the GDPR came into effect was the fact that it had this extraterritoriality. It didn't just apply, the GDPR didn't just apply within the EU, it applied to non-EU businesses as well that offered goods and services into the EU or monitored the behaviour of individuals in the EU. And the UK essentially will keep those provisions but apply them in the EU context. So non-UK businesses that provide goods and services to individuals in the UK or that monitor the behaviour of individuals in the UK will be subject to the UK GDPR. So if you're an international business that is neither in the UK or in the EU, you will be caught again by both sets of extraterritoriality provisions. You'll be caught by the UK extraterritoriality provisions and the EU extraterritoriality provisions. So again, it means that all of us are going to have a lot more legislation that we're going to need to be thinking about when we're advising our businesses and our clients. Next slide, please. And similarly to, as I was just discussing a few moments ago with the EU representative, because the UK GDPR is largely a copy and paste of the EU GDPR into the UK, we are also going to have this similar requirement to have to appoint a representative. So if you are a non-UK business, you will need to appoint a representative in the UK to represent you before the UK Data Protection Authority. And so that will be true whether you are an EU business or a non-EU business, because all of those entities will be non-UK businesses. And so consequently, if they're caught by the extraterritoriality requirements of the UK GDPR, they will be required to appoint a UK representative. So again, I expect to see some duplication there. Many businesses will find that they need to appoint both an EU representative and a UK representative if they're caught by the extraterritoriality provisions of both regimes. Next slide, please. So you can already see from everything we've discussed, there's going to be an awful lot of duplication, really, of obligations. If you look at the fact we're going to have this UK GDPR that will sit alongside the EU GDPR, we can see that there will be issues around the extraterritoriality provisions of both laws. There will be duplicated breach reporting requirements. There will be duplicated EU representative requirements. There'll be duplicated rules around data exports from each region. So there's going to be a lot for people to think about. And the consequences of those things are naturally going to find their way flowing into the contracts that we deal with. Because at the moment, obviously, when organizations do business, we will typically have provisions that will talk about in our contracts that will talk about the need to comply with EU data protection law and to manage the flow of data from the EU, and quite often as well, you will see contracts that refer specifically to the EU GDPR and articles under the EU GDPR. And what we're going to see after the transition period is that a lot of those template contracts are going to need to be redrafted. So to make clear, excuse me, to make clear that we are not just talking about ensuring we have provisions that enable compliance with the EU GDPR, but also that enable compliance with the UK GDPR. So you might, for example, need to go back and look at the definition of applicable law within your contracts to make sure that it covers both sets of data protection laws. Or if you are talking about compliance with specific articles of the GDPR, making sure that you are ensuring that those articles refer both to the relevant articles under the EU GDPR and the UK GDPR. And of course, when we get to the issue of data exports, making sure that the data export provisions of contracts talk both about exports from the EU, but also about exports from the UK as well. And specifically on that point, it will mean needing to have a look at the standard contractual clauses that you currently use as data exports. And we're in a slightly odd position here because once the UK is no longer treated as being an EU member state or a sort of an EU territory for the purposes of the transition period, the UK will no longer be will need to be treated rather as a data importer under all those standard contractual clauses you've drafted. So all of those SCCs that enable the exports of data from your business currently to non-EU organisations, and they list they list all the non-EU entities that may be receiving that data. You will now need to make sure that your UK entities are included within that list of non-EU entities that are signatories to the standard contractual clauses to enable them to import data from the EU, all of course assuming that the UK doesn't get adequacy. And there is also the slight oddity as well that we don't quite know, as Eleanor was explaining earlier, what the UK data export regime will be. And it may be that for a period of time, we enable data exports from the UK on the basis of standard contractual clauses as well. And in the same way that the exit regulations amend the GDPR so that they work in the UK, we have statutory instruments that can amend the standard contractual clauses so that they work in the UK as well. So you may have this slightly odd position where you have standard contractual clauses that list the UK entities as being data exporters under them, and also the UK entities as being data exporters to enable the import of data from the EU. So a very odd position, and hopefully we'll get more clarity around what the UK data export position is going to be in the coming months. Next slide, please. Another area of overlap, of course, with the UK duplicating the EU GDPR, under the GDPR, there is this requirement that you have to appoint a data protection officer if you satisfy certain criteria. Because we are essentially copying that law in that provision into the UK, there will also be a requirement to have a UK DPO if you meet the same criteria. So what that means now is that you will need to have a DPO not just under the EU GDPR, but also a DPO, potentially have a DPO under the UK GDPR as well. Now that may be one and the same person, but you will just need to make sure that you have made a formal appointment and you have appointed DPOs under both regimes if you meet the relevant thresholds. Next slide, please. So that really sort of brings us to the end of this section and the end of the presentation in total, really. So, what we've talked about, Ellen has taken you through how Brexit has developed to date, where we are in the transition period, what this means for the future of data exports both from the EU into the UK and from the UK back to the EU and the rest of the world. We've also looked at some of the kind of the wider consequences of having separate UK domestic data protection legislation from the EU GDPR and the EU GDPR not applying in the UK anymore, and what that will mean in terms of duplication and divergence and some of the consequential impacts of that. So that brings us to the end of it. I think the next slide has our contact details on the screen, and I'm going to pass back to Hazel at this point to see if we've had any questions coming in while we were talking.
Thank you both, Eleanor and Phil, for lovely, clear, excellent explanations of these tricky issues relating to Brexit. We do have a few questions. We have just a couple of minutes. So if you don't mind, I will ask you a couple of questions and perhaps you can see what you can cram into a couple of minutes. So the first question that came through that I think we need to address is, are there any indications with respect to a UK-US Privacy Shield type agreement? So have we heard anything on that, please?
Well, at the moment, data exports from the UK, again, bearing in mind that the UK is actually no longer an EU member state, technically, we wouldn't ordinarily benefit from the Privacy Shield arrangements between the EU and the US that were agreed between the EU and the US. However, the Department of Commerce and the US Department of Commerce has issued guidance that makes clear that for the time being, the UK can continue to export data from the UK to the US in reliance on the Privacy Shield, subject to some very minor tweaks to your online privacy statement, basically to make clear that you are extending the Privacy Shield principles you apply in the US to the data you receive, both to data received from the EU and to data received from the UK. As to whether we're going to formally agree a separate sort of UK-US Privacy Shield regime, I don't know, and I don't know, Eleanor, whether you've heard anything further on that.
I think it's all very up in the air. I mean, these conversations are ongoing, and certainly the conversations with the US are very much being prioritised with negotiators. That's one thing that Boris Johnson wants to show, that we have a good relationship with the US and that we are going to trade a lot with them. But as to the shape of that and exactly what's going to be agreed, I'm not sure, but certainly those conversations are very much ongoing. But of course, bear in mind, whatever we do with the US could potentially jeopardize the discussions with the EU. So if the US say we want a really light data protection regime in relation to data imports and exports between the UK and the US, that might be a red flag for the EU. So there's a complicated matrix of things that our negotiators are having to take into account.
Thank you both very much. I fear that we are coming up to the end of the allotted hour. So what I'm going to suggest is that we respond on the remaining questions and comments. And thank you very much. There are some lovely comments in the questions panel. And we will do that after the end of the webinar, just to make sure that all of you can get back to your desks on time. So thank you all very much for joining us. We will follow up with the recording and the slides, and as I say, the answers to the questions. Please do take a moment to look at our blog and any further webinars, and perhaps we'll be joined by you later on today at 4 p.m. UK when we will be running our AdTech webinar. Thank you very much.